is a small claim, Robert?
A small claim, in effect, is any claim for damages or money which is below £10,000.
Okay.
And it's one of three tracks we have in England. The small claims track, which is £10,000 and below, and then there's what's called the fast track, which is over £10,000 and below 25,000, and then there's the multi-track, which is above 25,000. And the difference between the three is in terms of disclosure, in terms of what you need to do in preparation for the trial, and of course in small claims tracks, costs, because costs are fixed and each side pays for its own costs, whereas in multi-track the winning party gets its cost paid, and in fast track.
Okay. But in business-to-business matters, what we do at Master Collections is we plead debt collection costs in the particular claim to make it less onerous for our clients to entertain a small claim where they've got those limitations, because it can get expensive.
Yeah, the costs I'm talking about are costs in preparation for the trial.
Okay.
So
the cost that we would plead.
The cost you're talking about is that's in terms
claim.
of the debt collector chasing up the debt. The costs I'm talking about are within relation to the case. So in relation to the debt collection having failed, as it were, and then taking it to court. And of course, other differences between the three tracks are that a small claims track will only, at the trial, I think theoretically it could be listed for a day. It doesn't often happen, but usually a small claims track will be 2 hours. Now a fast track trial is limited to a day, and then a multi-track case will typically be 2 days to several months.
Okay. And for the reasons discussed, judges will do everything they can to ensure that a small claims hearing doesn't go over 2 hours.
Yeah. Again, it comes back to proportionality. Why should a court, especially in these straitened times, spend any time at all on anything under £10,000? Important to the claimant and defendant, very important. But in terms of courts and the judicial process at the moment, not that important.
And with regard, sticking with costs in small claims hearings, are there any other situations where, for example, the winning party can claim costs?
Yeah, you can claim a few costs. So there's fixed costs which the solicitor or legal representative can claim, but they are limited to about £100, either side of 100. There's also witness expenses, which again I think is limited to about 50 to 100 quid, maybe £90.
That includes going to and from court?
No, and then there's witnesses' travel expenses, but everything is limited, so overall the winning side isn't going to get more than £200, £250. And of course they'll get the court fee back. Unless, of course, the judge deems that the defendant has acted unreasonably, in which case you're entitled to all your costs. But it's, in my experience, it's very rare for the judge to award those. Even really when I've been in a case, not one of your cases, in Manchester, where the judge had to find for us. We won the case. I was for the claimant. And the judge found that everything the defendant said was a lie. She didn't say it was a lie, but it had to be a lie. What went on at the meeting, the claimant's version was completely different from the defendant's version, and she found for the claimant. But even so, she said it hasn't met the threshold of unreasonable behaviour. So
despite
one can imagine
showing that the other side was lying.
Yes. Not just wrong recollection, but lying. And yet, it didn't count for unreasonable behaviour. But of course, this is another example of judges having, I would say, too much power.
They have a very wide discretion,
Yeah.
would you say, in small claims? As
They have a very wide
in contrast to fast track and
Yes.
multi-track,
Yes.
which would give you all the more reason to instruct.
It
Professional
does,
legal
because I think
representation.
you need a robust advocate, and then they won't be as willing as they are
Okay.
to make the law up.
And that's quite ironic, would you not say? Because the small claims track has been, it's my understanding, it's designed for litigants in person to avoid having to be up against a solicitor where they know they could lose and pay out a tremendous amount of money.
Yes, again, it depends. You see, I don't necessarily think it's designed for litigants in person, because most of personal injury is below £10,000. All your road traffic accidents. So you're in a car. Somebody bumps into you, you bump into them, you end up going to court because one side isn't admitting liability. Now, they're the backbone of the small claim courts,
Okay.
and they are all under £10,000, most of them under £5,000.
But aren't costs different in personal injury claims?
They are, and I don't think we need to get into that
Yeah.
here. There's what's called QOGs, qualified one-way cost shifting, and goodness knows
I'll
what.
get a big enough
But,
headache
yeah.
with the law in my case, is it like personal injury?
Yeah.
So, but the point of the matter is,
But the point of the
costs-
matter is that these are all, everybody's represented. And some of the top barristers, junior barristers from top London chambers, will be going to Edmund County Court or Brighton County Court on the South Eastern Circuit, and they're, my golly, are they represented. So it's not about not being represented, it's just about cutting down on the build-up to the case, cutting down on disclosure, cutting down on this and on that.
yeah, because disclosure in small claims hearings, what's the word I'm looking for? The requirement isn't as demanding as it is for multi-track and fast track. On small claims, it's documents that you intend to rely on.
Yeah, I mean, your typical multi-track
Whereas
case, for
fast track
example, a 2-day multi-track case will involve costs, and these are quite reasonable costs, the case I've just been on, and these are, allowed by the judges as not being out of the ordinary. A 2-day trial of multi-track will be about £35,000 on each side.
Wow.
And that's not being extortionate. In fact, in personal injury cases, until a few years ago, even though, and this is in the small claims, even though the award was for £3,000, cost would be £25,000, £30,000.
Surely that's disproportionate.
Which is why it stopped. Well, that's what the judges thought. That's what the judiciary thought, and that's no longer allowed. But you see, this is the whole thing about small claims. They're just as difficult to prepare. They can be just as time-consuming as your big cases. It's a bit like shares in the stock market. You can have a small company. Should we invest in a company market cap 2 million, 3 million? Now the decision on that is just as difficult as should we invest in, BP. Just as difficult.
So what's the lesson there? What would you say to people who are looking to go to court for a claim less than £10,000?
By all means
considering
do. Yeah, by all means do. You can't let that put you off. You have to do what you think right. But don't.
Solicitors won't be prepared to take on a small claim as complicated that would warrant those types of costs. It doesn't pay them to.
No, but you do get solicitors who specialise in small claims, and of course, although in court you only can get fixed costs, it doesn't mean your solicitor can't charge you more.
It was a pleasure having you in today, Robert.
Thanks.
An education, some fantastic information you've shared with our viewers. If there's anything in this interview of interest to you, please do get in touch. Our telephone number will appear at the end of the video. Remember, please like, comment and subscribe.